thanks for joining us. We're Chicago lawyers, and we're here to talk tonight about topics that interest you. We welcome your questions, and we're interested to get to know you. So, ladies, how are you guys doing tonight?
Great. How's it going?
Great. What's new with you, Elisa?
Doing well, keeping busy?
Oh, yeah.
Definitely. So I want to talk to the both of you tonight about estate planning and different things that happen in divorce cases and how you connect with your clients. What do you have going on, Dana?
Well, you know, I went to a meeting recently. I wanted to bring this up to you, Ish, because I was at a meeting and there were some estate planning lawyers and family lawyers there. And one of the family lawyers brought up the issue about when they're working a divorce and there is a pendency of the action, and if prior to the husband and the wife being declared divorced, should something happen to one of the parties and their estate plan is still in effect, then the spouse can ultimately inherit, because the spouse oftentimes is the person that, you know, the estate plan is typically written for.
Like what happens if someone dies mid-divorce?
Yeah, I mean, that's a really good question.
Before they get formally divorced, right?
Right, so mid-proceeding, what happens if someone
Because
passes away?
think about it, like right now I have a will and my husband is the beneficiary under the will. And that's normal when things are going well in the relationship. But if you're about to sever ties and you're ending a marital union forever, do you really want that person to end up with all of your property and your inheritance?
Exactly. So most of the time people come in and they want to leave, if something happens to them, everything to their spouse and then to their kids. That's a very common plan. And so now my question to you is, if they then put this plan in place and sometime later they start a divorce proceeding and this plan is currently in place, before they are formally divorced, are they allowed to make changes to their estate plans?
Absolutely, and I don't think any judge would think that that was odd. In fact, it probably makes good sense. What you want to do, though, is make note of the fact that the divorce is pending. And then as soon as the divorce is completed, my advice, if someone walked into my office, I'd say do it again. Because, Dana, there's no limit to the number of times you can change your plans. Isn't that right?
Yeah, but do you think they need to ask permission of the judge in the divorce proceeding?
I don't think you need to ask permission, because let's say, for example, someone were to die. I don't think anyone would contest the will stating that the intention of the spouse was really for their divorcing wife or husband to get their assets. So if the person dies during the pendency of the proceedings, I think everyone involved would understand that really their intent was for their spouse not to inherit, and there's really no reason why they should.
Couldn't something be recorded either in the court case or in the public records that dealt with that issue?
But wait a minute. If there's a plan that's been validly executed and one of the parties dies, if you are saying that everybody would know that they would not want their estate to pass to their estranged spouse.
Oh, no, that's not what I'm saying. What I'm saying is, if you were to change it in the middle of the divorce, everyone would understand why you did so. You're not doing it to really cheat somebody out of what was really rightfully theirs. Mm-hmm. You're doing it because the circumstances have changed. And my understanding, correct me if I'm wrong, is that in estate planning, the advice is to change what your wishes are as soon as circumstances in your life dictate that you should.
So what I want to understand is, if you're talking about the situation where someone has an existing estate plan and they are in the middle of a divorce, at what point should they change the estate plan prior to the divorce being completed? Is that the question?
It is.
Okay.
And whether they can do that under family law, because I understand that there is some restrictions on what you can do with your property.
We call it a stay, right? So as soon as the divorce proceeding is filed, the court orders a stay over all financial matters. This usually, though, refers to spending marital assets, or, ringing up the credit card bill, or, going on vacation and spending $30,000 of marital assets. But changing the beneficiary of a life insurance plan or a will, I think, falls under a different category.
So would it be advisable then, if someone is mid-divorce, to consider talking with their family law attorney about their desires to change their estate plan?
Well,
that's where I would start.
Yeah, I think it would be imperative, because if you have started a divorce with your estranged spouse, and your estate plan is probably written at a time when, you know, there were happier times,
Yeah.
you probably want to get those affairs arranged right away, so that should something happen during the pendency of the divorce proceeding, your estate passes the way you want it to.
Excellent advice, Dana. That's one I'm going to remember.
I think so as well. So that brings me to kind of a different topic that I'm interested to talk to you about, Ish, and that's the question of parents and kind of litigation and what happens if there's a criminal background and visitation. Do you have any thoughts on cases that you're working on that involve kind of rules that give people kind of a play-by-play on how to deal with the criminal factor in terms of visitation and divorce?
Well, one thing that I like to keep in mind is 3 strikes and you're out. And this is in terms of felonies. I mean, if you think about it, a lot of people think, oh, I'm going to lose, my husband is not going to get visitation if, you know, he gets arrested for a DUI. Not true. Courts will not restrict visitation for bad behavior or even for committing crimes.
So what about if someone is like a certified criminal or they have a criminal background, you're saying that doesn't come into play in the visitation?
Here's what the law says, is that visitation will be restricted if it's an endangerment to the child's physical, mental, or emotional well-being.
Isn't having a parent that's in a criminal or has a criminal background that's public record going to possibly impact them?
Not necessarily.
Okay, yeah, I agree. I think that that it's a case-by-case specific basis that needs to be, you know, looked at with scrutiny, because you're talking about a very serious relationship. I mean, I think that the mother and the father both play a vital role in developing a kid's confidence, you know, self-assurance, you know, all of these tools that the child develops when they're young and growing up. And once you remove one of those parents from the equation, it could have very detrimental effects.
I mean, I think a good question is someone who's been convicted of one crime or multiple crimes, is there something going on in their lives that would affect their ability to adequately parent their own child?
Yeah, judgment. Poor judgment affects someone's ability to parent
Well,
their
what the
child.
court says is if any of your crimes involved children, then it's very likely you'll lose visitation. If any of those crimes involved your own children,
oh my God, yeah, of course, yeah,
then I
clearly.
think it's a little bit more clear.
So what about if there's drug crimes or
Doesn't matter.
So would that then be a tool for the non-custodial spouse to talk about?
Well, let me tell you something in divorce. What everybody knows is people play dirty. I mean, they're trying to gain points, you know, pitting one parent against the other. And a lot of times, some parents get really excited when the other one starts acting out. And they're like, oh, yes, now the courts will never give him visitation or custody. But the truth is that courts understand that people are going to have mental illness, they're going to have substance abuse issues, and none of this necessarily means that they're going to be a bad parent.
So when is it time that maybe a guardian ad litem or an attorney that's designated for the child to advocate them is a good idea?
Well, I think if you have real serious concerns about whether or not this child is going to be endangered, and the people in that child's life are really the best ones to make that determination.
Yeah, I think that you're right. I mean, the people who spend the most time with the children are definitely the most apt to talk about what's been happening and what reactions the children have had. But I do think that a guardian ad litem is really helpful in cases too, because a lot of times kids don't feel comfortable going to their parents, you know?
Well, here's a tough situation. There was a case once under Illinois law where a mother was convicted of murdering her husband, which ended up being the child's father.
Goodness.
And yet, even in that case, the courts did not restrict visitation between the mother and her child. And I kind of think that might be a little bit confusing for the child in that case.
I think, just to say the least, you know, what Illinois courts do in terms of decisions, while it is case by case, I think that there's a lot of room for interpretation and maybe different ways for a case to be advanced by an attorney.
Yeah, but you know, that is a really hard one, because if you take the mother out of a child's life, I mean, you have to really consider what consequences is that child going to have as a result of taking the mother out. I'm not sure. I'm not so sure.
Yeah, but she took the father out of that child's life.
Well, I understand. Was she convicted, did you say?
She was, of murdering her husband.
I think that when mom is a murderer, the state has a responsibility to thoroughly evaluate whether or not fitness and custody and visitation are appropriate.
No
You
doubt.
know you can't have visitation in prison. That mother is still allowed to have her children come and visit her behind bars.
And there is, there is supervised visitation. So
We need to talk about that. When we get to Hot Topics, I think that this is a good one for us.
I think so. We can come up with something most definitely. It raises a lot of problems, and I think it depends on the angle angle from which you're kind of evaluating it. The state has an interest in making sure this child is safe and brought up in a reasonable fashion for the child's best interest. If the mother is a murderer and the father is the victim, then I think at the end of the day, the state has a responsibility to put someone in that child's life that's not a murderer and to ensure that they
Wait a minute. Are you saying that the child should lose both parents? Isn't losing one enough?
yeah,
I think
and
that when your
well,
parent is a murderer, that is on record, part of a court case, that the state has an interest in making sure that that child still has a chance.
But
Wait,
I
are we
think
going to
you're-
let
I
that
think you're-
murder define this woman? She's more than just a murderer.
Yeah, and
She's
I think
a
you're
mother.
glossing over a lot of the details.
I
mean, what if you're just labeling this person as a murderer? Shouldn't we at least consider the specific facts under this case? I mean, does she show any remorse? Does she, what were the conditions that caused this murder? I mean, I just don't think that the automatic answer should be, let's pluck the mother out of the child's life for the reason that she killed someone.
I
know
think
it's
that when you say if you change the situation and you're convicted of drunk driving, your license is taken from you. If you take the similar situation of having made an intentional decision on the assumption, on limited facts that I'm going on, that it's an intentional crime, of course we can examine the circumstances to figure out what it is that happened. But to the degree, if it's a minor child, I think that the visitation should be restricted and supervised to make sure that it's in the child's best interest.
Well, you
Not
bring up
that
a good point, Elisa. There are other ways to deal with the situation rather than completely terminating parental involvement in the child's life.
Right.
And you mentioned a good point. Supervised visitation is a wonderful solution. Sometimes restricting overnights or restricting the environment under which the visitation takes place, that can also be effective as well.
But if we're talking about this, I think I'm assuming that the mother is incarcerated. So if the mother is incarcerated, then clearly there's already the supervisory component in there, and there's already de facto restriction on access. But to the degree that if it's a capital crime, I think that creates a presumption that there should be an automatic restriction. How that's implemented is going to be case by case.
You know what there should also be is automatic therapy. I mean,
Oh.
this kind of case is just craziness.
Yeah, but
First
do you
of
get to
all,
pay for it, Dana? Should our tax dollars really have to pay for that?
You know what? If our tax dollars are paying for some baby rattles in the courthouse daycare room, then our tax dollars should also go towards paying for some therapy, because these are serious issues that really impact, a child's. I mean, I just can't imagine the depth of the issue and where it lies within that child who is trying desperately to understand what has happened and doesn't even realize the impact that it's going to have on that child.
Yeah, I think that really gives us food for thought for future episodes. I am interested to change our gears just a little bit, because I was excited to talk to you two about construction law issues and talking about how everybody owns a home or rents a home, and how we can.
And everybody builds a daycare.
Everybody
builds a nursery.
Everybody buys a Christmas tree. To really talk about how people can avoid construction law claims when they own a home. Have either of you ever dealt with hiring a contractor and having a problem in your home?
I wish I had hired a contractor. I really need to get my kitchen done, so I think I need to listen to this.
Well, in a prior life, I used to run a construction company.
Did you?
So I want
Oh,
to hear about
Dana,
this.
we had no idea.
Yeah, I had a business for 11 years with my ex-husband. We had a construction and remodeling company.
That is interesting. So then this will tie right into a lot of the things that you probably dealt with. One of the things that I wanted to talk about is just how people can be sure of who they're hiring. It's really common these days to go on Craigslist or Angie's List and say, I need a drywall guy. Who can I find? And people will solicit, names and numbers of people. What I find is really common is people find, homeowners will find a contractor online. They'll invite the contractor over and they'll get a bid, and maybe they'll accept the contractor for doing the work, but they won't necessarily bother to explore who that contractor might be hiring and bringing over to the job.
Well, do you have any control over that, or?
You do, and maybe not to the degree of limiting them, but you can make an agreement with the contractor to say, you know, if I hire you as a contractor to do my drywall, are you going to subcontract out any part of that work?
Wait, but do they have a legal duty to disclose that information to you?
I think they do.
No, I don't think they have. You do not. Coming from the biz, you don't have a legal duty to disclose the subcontractors that you're going to use. But if somebody asks you the question, what subcontractors are you going to use on my job, if any, I mean, you certainly, you could run into problems if you lie about it.
I would disagree to the extent that the Illinois mechanics lien law requires all contractors who are working at least on a single family project to notify the homeowner that they're there. So since this is standard practice in single family home projects, that if like a general top tier contractor hires contractors below them to help with the project, that lower level contractor is obligated to notify the homeowner. So is sort of a disclosure component. So my suggestion is the corollary is that the homeowner therefore require the contractor to disclose who if anyone do you plan to bring on site, are you subbing out any of the work, so that I can manage who's in my house and therefore who could place a lien. Because if you leave it open-ended, if Acme Builders hires Smith Company to come and do painting after the drywall is done, and Smith Company isn't paid, if you don't know that they're there and you make an assumption that Smith and Acme employees are from one and the same origin, then you as the homeowner have made a mistake and you've opened yourself up to exposure for a mechanics lien, which then can trigger litigation and other issues. So my suggestion is that in the bidding process, you make that part of the contract to say, contractor must disclose all staff on site.
Yeah, I definitely think it's a good practice. But just to clarify what you had said, under the Mechanics Lien Act, the subcontractor has to disclose to the homeowner that he's there?
Yes, for single-family home projects only. I think it's a bad idea that the legislature limits it only to single families, at least given the prevalence of condominiums. But in Illinois for right now, it's single-family homes. So the subcontractor is required to send a letter within 60 days of arrival on the project. So they call it a 60-day notice, and
the whole house can be built in 60 days. I mean, that's a long time. A subcontractor can be in and out, in 3 to 5 days.
Certainly.
And then 2 months later, you get a letter. Oh, by the way, I was at your house 2 months ago.
And I stole your wedding rings, but I'll save that story for another day.
Sounds like you know something a little bit about that. But no, the subcontractor has a 60-day limit on sending the notice. You're absolutely right.
Okay, but the general contractor has no duty to disclose. But you're saying that it's a better practice of the homeowner to require that as part of the contract.
I would think so.
Right?
And what happens is very common is that people will do deals on the handshake. They will not have it documented who's to be on site, so that in theory they don't really know who they're hiring, and therefore they've left themselves open to maybe have an unknown process creep in, which is the mechanics lien problem. And that sort of goes to the corollary of if you put everything in writing and you use a form contract that you find online or you have the contractor provide to you, it can be good. Like, for example, I'm trying to have some work bid out on my house, and the contractor sent me an email in literally paragraph form of what the bid was. Not only was it unprofessional, I thought, this is not the contract. And to him,
is an email binding? I've never really thought about that before.
Certainly it could be.
If
you show a meeting of the minds, I think it can definitely be binding. My concern is that I wanted to compare line by line my different bids, and the structure was a little bit different. So I asked him, I said, could you please requote in such and such format? And
Elisa, aren't you a little bit particular? I mean, print it out and compare it yourself.
I think that personally, this was a matter of presentation, and I wanted the contractor to give it to me in a certain format. But regardless of my intricacies or strange ways, it's still good for a customer to have the information in writing, clear what's the agreement, who's going to be on site and what's going to be done.
I definitely think that's valuable advice. And what I really like about what you're saying is that homeowners need to advocate for themselves.
Absolutely.
Why wait until something happens,
You know,
right?
I vaguely remember that there is a requirement in Illinois for general contractors to provide some disclosures. Does this sound familiar
It
to
does.
you? There's a consumer's guide or
Yes.
Illinois Residential Disclosure Act or something like that.
In real property sales, there's the Residential Real Property Disclosure Act, and then in construction, it's the Consumer Home Repair and Remodeling.
That's the one. That's the one.
So,
Consumer Home Repair and Remodeling Act.
That's right.
Yes.
And
Can
so
we find that online? I've never seen that before.
Absolutely. So you can Google Illinois Consumer Home Repair and Remodeling Act. Also, it's a kind of a subset of the Illinois Consumer Fraud Act. So they have different ways of requiring contractors to take certain actions.
And in fact, a lot of contractors don't realize they have this obligation.
That's right.
Because I came across it on accident when we were in the business, and I saw all these requirements that needed to be fulfilled, and we started doing them right away. But there isn't any birdie that comes and sits in the window to tell you when you're a contractor that this is what you need to be doing under the law. So I think there needs to be some better communication.
Definitely.
And require everything in writing, people. It makes so much sense.
That's definitely true. Well, I want to ask you two questions. If you've heard about this Heather Mack case and what's going on where this woman, Heather Mack, was currently awaiting trial in Bali for potentially killing her mother-in-law.
Oh, yes.
I
She's
remember this story
pregnant,
from,
and
wasn't it a year or two ago?
I think so. And she and her boyfriend accompanied their mother or the mother over to Bali. And as it came to be, the mother was found dismembered in a suitcase. Now the female and male are now incarcerated in Bali. And this woman, Heather Mack, just had the baby. And the question is whether or not she can be allowed to have her baby in jail in Bali.
We were just talking about visitation. I mean, just because she's under the assumption of having killed her mother doesn't mean she shouldn't be able to parent her own child.
But
Okay, wait a
doesn't the
minute.
United States have a right to get their own citizen? That baby's a U.S. citizen. Shouldn't the United States rescue that baby
Wait a
from
minute, let
jail?
me get some facts straight. Okay, so daughter and her boyfriend are in jail in Bali.
Yes.
And
The mother was an Illinois citizen.
I remember that. I think she was from the north side. And daughter and boyfriend were not convicted, or they were?
It's still under process. We're not sure what the outcome of the case will be yet.
Okay.
They haven't been convicted
And
yet.
she had the baby.
In jail, that's correct.
Okay. And
she wants to keep her child with her. I mean, wouldn't you? It's a mother and child relationship. Why should she be deprived of that just because she's been accused of a crime?
Why should a U.S. citizen be stuck in a Balinese jail until they're 2 years old? They're naturally being deprived of everything that a safe home environment has to offer.
I think that there are some, again, real repercussions to removing a child from its mother. And especially in this case where we don't even have a conviction. I mean, I'm not sure what the legal standards are over there, but we don't have any conviction.
Did you see Brokedown Palace? I mean, the conditions of a Balinese or foreign jail, if they can't be identified or ascertained, doesn't the United States have an interest in protecting its citizen that didn't commit a crime?
Well, if you
Wait
think
a
about
minute.
what we talked about in terms of Illinois law, Illinois would value the relationship between mother and child above all else.
But so Bali law provides that the mother can keep the child for up to 2 years. So the first 2 years of the child's life, arguably some of the most formative years, that child could be stuck in jail without a play yard, without adequate nutrition.
Listen, Elisa.
The first year, the playing is like this anyway. Gaga, goo goo. The first year, the child is not going to know if it's in Disney World or if it's,
We're all moms here. I would disagree.
But
we
I
all
think
have
the child,
so many resources in raising our babies.
My point is that the child will know if it's without its mother. But put a child, in Disney World with all the Mickey Mouse shaped bushes, or put a child with its mother in a cell, I think is more beneficial to the child to be with its mother.
So you don't think that there's any argument to be made for having family members step in to bring the child back to the
I
United
think
States?
if there are family members that are willing and able to parent the child, that should be part of the story
What?
here.
Yeah.
Wait a minute. What about the mother's right to her own child?
Maybe
Well-
she shouldn't have dismembered the mother and left her in a suitcase.
But we don't know that for sure. That's the problem
Innocent
here.
until proven guilty.
I think that there's got to be a question of why the person is incarcerated. We have to examine the Balinese legal system, but there's clearly a question that raises some doubts as to whether or not there's evidence. I don't know that evidence as I sit here right now, but to force the child, I'm advocating for the child. I think the child needs to be in safety, and a Balinese prison doesn't strike me as being safe enough.
Well, I will say one thing I read in the story is that if you have money can buy a pretty comfortable prison life for you over there.
That's
And I
true.
hear
You're
Bali
probably-
has some nice views.
Bali does have some nice views.
Dana, we're not talking about vacation.
She wants to talk. You can go on a vacation.
She
Fine,
wants to
fine.
go on vacation.
So anyway, I want to thank you all for joining us tonight. Please be sure to visit us on social media. Keep us informed. Let us know what your comments are so we can continue to talk about the things that you find interesting. So thanks again for joining us.
Good evening. Thanks for joining us tonight. We're here to talk about things that interest you from different legal perspectives, and we hope you enjoy the show. How are you ladies doing tonight?
Good. How are
I'm
you?
good, Dana.
Good
Good
to see
you.
you.
I know.
You.
What have you been up to?
Well, I went to a meeting recently, and there were estate planning.
Oh,
lawyers.
imagine that. What a
There were
surprise.
estate planning lawyers and
So much fun.
and family lawyers there, and we were talking about a case that interested me because what happened was there were two people who got married later in life as a second marriage, and they both had kids from a prior first marriage who were adults at the time. So these two lived out their marriage together for a couple decades, and then one of them passed away. Now, during their lives, they created an estate plan jointly, which essentially said everything to the survivor, and then when the survivor goes, all of our estate gets split amongst all of our children in equal parts.
Is that standard?
Yeah, I mean, it happens.
Okay.
Yeah, for sure. Now, what interested me about this case is that when the husband passed away first, okay, so now his wife was a widow, and she at first had good contact with all of the children.
Oh, I know where this is going.
Her children and his.
Became your side of the family versus his side of the family.
Well, the time goes on, and it's not too clear from the facts of the case, but she started to distance herself from his son, and eventually she cut off contact with him. Then she passed away, and in between the time when she cut off contact with him, but before she passed away, she changed her plan.
Oh, that doesn't sound
To
good.
disinherit him.
Basically, yeah.
Okay.
She changed her plan to give it to her children
Does she have
only.
the right to do that?
I would think so.
Well,
Wait a minute, but that wasn't the intention of the husband when they were still both alive and they created this plan together. How can she change it now just because she feels like it?
I know.
Can't you do that?
Well, it's a little bit complicated. I mean, you always have the right to redo your plan unless you entered into a contract.
Oh, not to do that.
So yeah, you might have, you might be obligated under a contract that you agreed to at the time.
Who would have standing to enforce that if the other party's deceased?
Well, that's what became interesting because I didn't even get to the other part of this case that really puts a twist on it. She, at the time she passed away, his son did not know she passed away. And what
Because they
happened
didn't have
was,
contact.
because they didn't have contact
Okay.
and she had moved, and then what happened was her estate was probated, and then a period of time passed where he no longer even had standing to come in to contest
Because
the
like
issue.
a deadline came in
Yes.
terms of making claims.
Right.
Okay.
So he came back after this deadline passed.
And I bet after her children were really enjoying the assets of the marriage.
Well, I mean, it didn't even go that far, because he came back in to try and say, you know, there was a contract here and he wanted to prove his facts, but her children said, we're going to file a motion to dismiss this because he doesn't have any standing in this case.
That's the way I would go.
And I just felt so badly for this poor guy.
Oh, Dana,
because
quit
wait a
feeling
minute,
bad
wait a
for
minute.
people.
What wound up happening was, you know, his dad had pieces of his estate that went to his widow, which then went to her children, that originally belonged to the son's father. I mean, you're talking about some sentimental value, and it went all the way down.
But wait a minute,
to
is
other
the law
side.
here to be sentimental? I mean, quit it with all that
No,
mushy,
wait a
mushy
minute.
stuff.
The law, the law, I think, is definitely.
Can you say that in court? Can you say "fooey" on the mushy mushy"?
That is a legal term,
Phooey
I
on
will
the
tell
mushy
you.
mushy. I've argued "fooey" before.
I think the law is here to try and, you know, create equity, right? Isn't that what we're supposed to be doing? Is you
Every
know,
time I use the words justice and
Lady
equity
Justice,
in court, the
does
judges are
that-
not
does-
usually impressed. But
Does Lady Justice ring a bell? So
I've heard of her, but she hides.
I thought of how could we have prevented this case? You know, because oftentimes things that unravel in probate, estate planners will then think, how could we have prevented this? You know, at an earlier time, and so it comes back to what you were saying, Elisa, about when they formed a contract. I think it should have been included in that contract that the survivor of the two of them has an affirmative duty to keep all of the children informed as to their whereabouts.
I think
Or,
that's certainly
you know,
reasonable.
I mean, one doesn't know if it would have made a difference in this case, but
But I think it kind of goes to the survivor of the married couple. At one point in time, she thought of her husband's children as children of the marriage, if not necessarily her own children. So even though once they parted ways, her affinity for them became less and less as time goes on, she's still a stepmother, kind of once a stepmother, always a stepmother. So maybe that's where the obligation comes in. But there's a period of time that maybe the claims go away, and that's what the law has to clarify of how long the kids have. They certainly knew about the divorce.
yeah. Well, that's something to think about in the future, you know, especially for any family who has a blend or a, you know,
Or even just a
divorce
divorce,
or change.
when there's adult children, there's a way to kind of deal with, you know, how we all get together and talk about the relationships for going in the future, whether
But
that's
Dana,
college
you
or,
know, well, one thing that when you were speaking, it really reminded me of an issue we have in family law, which is that sometimes cases go all the way up to the Illinois Supreme Court, and it makes the rest of us practitioners think, how should I advise my clients so
Yeah.
that they don't end up in a similar situation? Do you have a minute? Can I tell you about one of these cases?
let us know.
Definitely.
So this was a college contribution matter. And what happened was the parents, when they divorced, the children were still quite young and college just wasn't an issue. Well, fast forward about 20 years and now mom has raised her sons and they want to go to college and mom thinks that dad should contribute. And dad says,
And he should.
Dad says, no way. I never agreed to that. You can't make me.
because he's thinking that his responsibility is only until the children are 18 years old.
Well, that's right. And he also thinks, you know, why should I have to? I mean, it's not a right. It's not part of civil rights to have an education at a college level. Not everybody does. And then he, quite frankly, didn't want to spend his money that way.
So how did that case get resolved?
Well, the Illinois Supreme Court has ruled that when parents get divorced, they do have an obligation to each contribute to the higher education of their children.
Wow.
Thank God. You know what? Thank God. I think absolutely that should be the case.
Well, but it raises an issue, though, because normal I shouldn't say normal, but I should say married couples that are not going through divorce, they don't have such an obligation. So why should you, just because you're getting
They
divorced?
don't have such an obligation.
What about that?
Married couples who are married absolutely continue to contribute to their child's.
Wait a minute,
They
but
don't
if
have an
I
obligation
don't
to send them to
want to,
college.
if I don't want to, no one's going to make me send my child to college and pay for his tuition.
What about, there was a case, wasn't it, in New Jersey, where the young woman sued her parents for college tuition, and the case was dismissed because, at least in New Jersey, there wasn't an obligation of the parents to actually further
Fund the college tuition.
right.
And I mean, just personally speaking, I paid my own way through school, so no one made my parents pay for me.
And I'm not trying to say that I think parents have a duty to pay their kids' college education, but I think that the obligation of the parent to contribute towards helping their children in their lives doesn't end at age 18. I mean,
but that's us, the mom talking. We're always parents, and we always want the best for our child. But when does it stop? If it doesn't stop at 18, if the parents can be forced to fund college expenses, when does that end? At 30? At 35?
Especially, you guys know what the raising tuition rates are now. I mean, even going to a state school is not like it was 10 years ago. This could put a serious financial strain on parents who may not have anticipated having to spend this money.
Well, what about, I'd be curious to understand how a judge would reconcile differing desires from parent to parent as to what college is acceptable, what the child can study, a veterinary program versus a different program, or, I mean, the different costs in different schools. That's a huge issue nationwide.
Yeah, but it is really similar to the issue of extracurriculars for children when they're minors. You have the same argument that parents put forth. I want to enroll the kid in X number of extracurriculars, and if the other parent isn't agreeing to pay for those, then the other parent is saying, I can't afford it, I don't agree to it, I'm not going to do it. And what happens in those cases? It's in the best interest of the child. I correct me if I'm wrong, but it's in the best interest of the child to be active in some of these extracurricular activities, and so courts will find contribution from both parents in those cases.
I think what's most important to remember, there's no easy answer to these questions, but if you are getting divorced, you are putting yourself under the jurisdiction of the court. So if you don't want the court to decide your personal business, you probably should just stay married. Think
goodness.
about it. You're giving up certain
hard.
rights.
It is hard to bring the court, because now it's like a marriage of 3 people.
That's right. That's exactly right.
However, did you ever do those psychology tests in college where the whole class gets a worksheet and you have to answer it how you would answer how you would do it yourself, and then you get into small groups and you guys all have to answer the same thing? Does this ring a bell?
No, that wasn't the psychology test I took in college.
Well, the point is that almost always is the group going to survive over the individual answers. And so more heads at the table are better than one.
Wait, you're saying legal involvement in your life is better than without?
I think that sometimes having the court involved could really facilitate the best interests of the child.
I think that's true as well, because there's an independent party between the judge and possibly a child's attorney that can get involved to help.
Yeah.
Well, and one thing I want our viewers to understand is there is something that we call, colloquially, Section 513. It sounds like part of the criminal code, but it really applies to this issue of college contribution. And what Section 513 says is that when a child becomes of college age, what the court will do will take into consideration the financial ability of all 3 parties to contribute to college, right?
Including the child.
Including the child.
That's
maybe
good.
he has financial aid, or
Yeah,
maybe they're
that
going to
makes
get
sense.
a job. So everybody plays a part, and I think that's really smart.
I'm going to switch
agree.
gears
Yep.
because I want to talk about when you're a landlord, what forms should be handy at your fingertips.
I can
Want to
talk
get to
about
the
that.
subject?
Absolutely. Well, okay. So when you're a landlord of any kind of property, you really need a contract between yourself and the tenant. So that's typically known as a lease, but it doesn't have to be called a lease in order to be a
Really?
lease. Yeah.
What else would you call it?
contract between Juan and Bob. It really doesn't matter. I mean, most people call it a lease, but regardless, it's substance
Rental
over
agreement.
Yeah,
Oh, that's a good
substance
point.
substance over form. So
Housing agreement.
if the gist of the document is to rent property from the landlord to the tenant, the title at the top is not really the main issue. But what I generally represent landlords in my practice, and many times I'll get a call of, do I need a packet, or, should I pre-prepare something, or should I buy something, or should I hire an attorney to do it? Now, all of those are really good.
Yes, 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 yes.
I always say yes to that one.
But there are so many options, especially in a large city like Chicago, that, there's different ways to handle or kind of skin the cat. So the way that I generally advise clients is I say, you need it in writing. You need a document that covers the property, the rent,
what about the security deposit?
The security
Right.
deposit. If there's an ordinance in your municipality that deals with certain things that have to be in the lease, like there is in Chicago, then there come to be known standard forms that are very popular. And
George Cole. Has everybody seen George Cole?
No,
George
what are you
Cole-
talking
George
about?
Cole.
George Cole was a guy.
He's got to be 100 years old because he has been, I'll go through title searches and people use deeds, general form deeds
Yeah.
prepared by George Cole.
So George Cole, there was a form company. I'm a consultant for a Chicago form company, and so it's kind of a popular business that to be in the form business. Just as easily, you can go to a lot of the big chain retailers and find form documents. But again, it doesn't really matter where they come from. It just
I
has
have
to
to say,
contain certain
you have to be
information.
careful about some of those stock
Yes,
forms.
you do.
Because they're
Because
written.
the law changes, right? So maybe they wouldn't be
I mean,
applicable anymore.
Even the fact, besides that fact, what I'm trying to say is that those forms are broadly written.
Yes.
They want to cover kind of your basics.
Yes.
But the problem that people run into is that they might not cover the nuances.
One size does not fit all.
Well, not only that, they don't come usually with an instruction book, because then that puts the form company at risk for saying too much or saying
Right,
too
giving
little.
some legal advice.
Yeah, so what I do is, as a consultant for the form company that I work with, is I talk about that, and I talk about, what do I think that the customer understands about a particular line or provision. If it looks weird, or do I think that it's confusing, I'll at least give an opinion, let's take this out, or let's include an instruction sheet. But in terms of the leasing relationship, it's really important that we have the landlord has an understanding of what's necessary. So many times a municipality will say certain disclosures, lead or electricity, or now in Chicago there are bed bugs. So there are just these disclosures.
Wait a minute, what do you mean now in Chicago there are bed bugs?
There's a bed bug disclosure form that the landlord has to provide to a tenant. And it talks about what the landlord's obligations are and what the tenant's obligations
Well, will it
are.
tell you if there were bed bugs in that apartment?
No, well, the form itself doesn't, but it imparts upon the landlord an obligation to disclose that if in fact it was the case. And especially
Do
because
hotels have to tell you?
I wish, good Lord.
Dana, that is off topic right now.
No, it's not. We're talking about bed bugs.
We're not talking about bed bugs. This is not a show about bed bugs. Please, please. But to the degree that a landlord could be obligated to talk about it, there's a required pamphlet which makes that one of the check marks. So usually what I do is I recommend that a landlord, every time they enter into a lease, they go through a series of like a checklist, so they make sure that everything's included. A receipt for the deposit, a completed lease, any disclosures that they are required by law.
Can a landlord get in trouble if they don't have a lease that covers all of the necessary components?
Absolutely. In Illinois, and specifically in Chicago, the landlord is held to certain standards. If they violate those standards, which are simple to follow, but if they violate them, there are strict penalties which can be very, very costly. So I definitely recommend that landlords give out a simple packet that has everything that's required, and they just analyze it every year to make sure that it's up to date. And then it's a fairly straightforward process.
Do people hire you as kind of as needed basis,
Yes.
or how does that work?
Well, once I form a relationship, they can email me anytime or call, and or lots of times clients will, send me an email and say, "Hey, Elisa, can you take a look at this?" And I'll gladly do that. People will hire me just to draft a contract or review.
I bet you were wishing that Juan Rivera called you and said, "Are you busy?"
Well,
Have you heard about that case?
I have.
I did.
I
That's
wasn't.
some award, isn't it?
Juan Rivera, $20 million. I think it's the biggest settlement for a wrongful conviction case. I believe I heard
nationally
that.
or in Illinois?
No, I believe I heard nationally that it is
That's
the
great.
biggest settlement to date.
I heard on the news today that a prosecutor in a related case took out a 3-page ad in a local newspaper apologizing to the state and to a victim who'd been wrongly accused because he believed, this was a Louisiana case, that his standards for the prosecutor's thought process on the conviction changed over time.
Wow, I don't think I've ever heard of a lawyer apologizing for anything. Have you?
It happens from time to time, but they're very elusive.
So what do you think about that? Juan Rivera, $20 million for 20 years.
Well, I don't know. Can you put a price tag on freedom?
He said that specifically in the interview, that he, didn't care about the money if he could have had those years back. So having, received a huge settlement doesn't give him the happiness, even though he's really glad and tremendously
so then maybe
thrilled
we
to,
shouldn't have given $20 million.
Well, but it's
Can we
sending
scale it
a
back a little
message.
bit?
I mean, think
where does the
about
money
it.
come from?
But it has to send a message to the cities and to the counties and to the prosecutors and to the police department and to everyone involved in these types of cases that we've got to stop doing this.
Do you think anybody's doing this on purpose?
I think that defense attorneys are overloaded. I think a lot of it can start with the prosecution and the defense. Both sides are clearly not doing their jobs. The prosecution is putting away an innocent person. The defense attorney is clearly making some sort of mistake somewhere, that there was a conviction when the person didn't do it, so there has to be a gap. But wasn't there a plea in this case?
Yeah, first I want to say I agree with you. I mean, fundamentally, the system needs to be tweaked. As you both know, I think that we do have some, Sacred Hearts behind the curtains who are really trying to do the right thing.
Absolutely,
But
I agree.
I agree with you that, it's not a perfect system and there is room for improvement. I mean, I think DNA coming into the picture helps a lot.
Why did it take 20 years for DNA?
But should we really have to rely on that? I mean, should every case boil down to that these days? That's what it seems like.
Well, DNA evidence was around 20 years ago. It just wasn't as easily accessible, and maybe it wasn't affordable.
I think I've heard that getting DNA off of objects it's not so CSI like.
It's not an exact science.
Well, the Illinois Crime Lab's
no,
not
not that it's not not that it's not an exact science that's not conclusive, but rather if you think that you can just get DNA off of now you're going to get my DNA. It's not so easy to get. I've heard
you just
that
left your DNA on my computer.
I've heard that extracting DNA evidence can be very difficult. So I'm sure there are a lot of,
Well, we don't want to leave it to the CSIs, to fix our problems, but the judiciary, the jury system, the capital punishments. I mean, automatically in capital crimes, there's an appeal, but those processes take so long that you can easily see, if you get into the thick of the judiciary and the legal system, why it takes 20 years, because all of those appeals had to be exhausted. I work on appeals all the time, and they are very lengthy in the civil realm. And so,
but I think what's important in this case is everyone looks at the dollar amount. Oh, $20 million. I'd love to have that.
I was just about to raise it again.
But think about it. I mean, that's time you can never get back.
he said that in the interview, that he missed his kids' graduation and he didn't get to grow up with them. And I think that goes to what we were talking about earlier, is that if you're really putting a premium on the parent-child relationship, if he didn't commit the crime, then he shouldn't have been incarcerated. So I know, from my exposure to the criminal law, that it's really important that we examine what's happening with the attorneys. How is the case being prosecuted to beyond a reasonable doubt? And if there's a plea in this case, why was there a guilty plea? Because
this is Illinois. Okay,
I
we've heard about coerced confessions.
Well, it's not John Burge, but at the end of the day, there are issues with confessions. But there's this thing called an Alfred plea, where the defendant can make a plea and say, I'm innocent, but I will plead guilty because I acknowledge that there's enough evidence to charge me and convict me with guilt beyond a reasonable doubt. So that even creates an inconsistency. Is if you say you're innocent, but you acknowledge as a defendant that there's enough evidence to convict you beyond a reasonable doubt, then either our beyond reasonable doubt standard is in question, or you shouldn't allow.
It's logically in conflict.
But if I think about myself as that person and I'm facing life in prison and someone tells me to sign on the dotted line, I don't care what you're going to make me sign to. If you're going to give me the chance of seeing the light of day, I'm going to plea out.
But the thing is that if you have the chance of winning your case because you are in fact innocent.
Wait. Are we going to pretend that you win because you're innocent?
To the degree that if a defendant is innocent, he should never say he's guilty unless
we're saying from the perspective of the defendant.
Well,
if he knows he's innocent,
from the perspective
then why?
of a perfect world in which we don't live in, I would never advise my client to sit there and claim innocence if he's facing life in prison without the chance of parole.
But if
I'm not a criminal law attorney, I have to say that. But
and none of us are. But that's exactly what makes it so important about the discussion is that the general public thinks about these things, and there's so much media coverage of these criminal law cases. But what is not as exposed or delved into are these intricacies of plea bargains, how we get to a plea bargain, is there assistance of counsel at that time?
You know, I'm laughing right now because I remember my criminal law professor in law school.
Pain.
And what she always used to say was, plead out. That's what I always tell my clients, plead out. And we would all laugh about that. But, you know, it kind of makes sense. When you hear about these stories, it just, wow.
I tell my clients to do it in a real estate context, so I understand. It's the time value of money, it's the time value of truth, and it's the time value of justice, all of which are, in theory, sometimes inconsistent principles.
Well, thank you, ladies.
You're
With
welcome.
that, we are going to go
Time
out. Thank you for joining us. We hope you really enjoyed the show. We want to hear what you think. Give us a call, contact us through social media, Facebook, email, Twitter, smoke signals, however you want to. We want to hear from you. Have a good night.